Production and distribution of City Club forums on IdeaStream Public Media are made possible by PNC and the United Black Fund of Greater Cleveland, Incorporated.
Good afternoon, and welcome to the City Club of Cleveland, where we are devoted to conversations of consequence that help democracy thrive. It's Thursday, June 20th, and I'm Cynthia Connolly, Director of Programming here, and honored to introduce today's forum. We're here in partnership with the Moyer Legacy Committee. The committee was formed in 2010 to honor the late Chief Justice Thomas J. Moyer and his dedication to the administration of justice and public understanding of the law. Today, we will get to pull back the curtains of Ohio's Supreme Court. The Supreme Court of Ohio is the state's highest court and the court of last resort. The court decides Ohio's most difficult, complicated, and contentious legal cases, mostly appeals from 12 district courts of appeals. Since 1803, the court has provided leadership for Ohio's judicial branch and administered Ohio's court system. Today, we will hear about the critical role of the Supreme Court of Ohio and its extraordinary history straight from the very justices who served and spent their careers dedicated to the rule of law. The Honorable Yvette McGee Brown is partner at Jones Day and former justice of the Supreme Court of Ohio. A series of firsts defines the life and career of Justice McGee Brown. She is a first-generation college graduate, the first African-American woman elected to the Franklin County Common Pleas Court, and in January 2011, she became the first African-American woman to serve as a justice on the state's highest court. Also joining us is the Honorable Terrence O'Donnell, who joined the Supreme Court of Ohio in 2003 as its 149th justice. He is a former school teacher and began his judicial career in 1980 on the Cuyahoga County Common Pleas Court. He served there for 14 years until his election to the 8th District Court of Appeals in 1994. Moderating the conversation is Justice Patrick Fischer. Justice Fischer began his first 6-year term on the Supreme Court of Ohio in 2017, following his election in November of 2016. Previously, he had been twice elected to serve as judge on the 1st District Court of Appeals. If you have a question for our justices, you can text it to 330-541-5794. That's 330-541-5794, and City Club staff will try our best to work it into the second half of the program. Members and friends of the City Club, please join me in welcoming each of the justices here today and handing it over to Justice Fischer.
Thank you very much. But before we begin, usually this time of the year when we have the State Bar turnover meeting, changeover meeting, and it would always be the same week as somebody's birthday. Bill Weisenberg's 80th birthday today.
Happy birthday, Bill.
Please, happy birthday
to you.
Happy birthday to you. Happy birthday, dear Bill. Happy birthday to you. Now, real quick, the advantage of my position is I'm going to ask questions that I can't answer as a sitting justice. But they're former justices, so they can do it. And not only are they former justices, they're now practicing law. So they can answer these questions, okay? So you all are getting a very unique opportunity. And the one question I have for both of you, most of the questions are going to be individual, but what is your best memory of being on the Ohio Supreme Court?
Well, my best memory is serving with Yvette McGee Brown. That's the best for me. But let me just take a moment and say what an honor it is to be a participant in the Tom Moyer legacy and to be here in Cleveland at the City Club new headquarters. This is a fantastic facility, and I'm very honored to be here. And a quick story about Tom Moyer, because he really was a unique individual. He served 24 years as Chief Justice of the Ohio Supreme Court. Everybody knew Tom in Columbus. And he always loved the story that I told him about when the Pope came to the United States, landed in New York, and switched places with the limousine driver and was driving the limo and got pulled over for speeding. And the police officer who pulled him over, of course, calls the sergeant and said, I cannot give this guy a ticket. He said, well, why can't you give him a ticket? He said, I have no idea who he is, but the Pope is his driver. Tom loved that story. So here we are in Columbus in a court week, and Tom calls and says, you want to go to lunch? I said, sure, that's fine. This was on a Tuesday. So he said, I'll meet you in the parking garage. So I come down to the parking garage. I'm a little bit late. Tom's standing there sort of looking at his watch. He says, oh, I'll drive. So we jump in his car, and we're driving up High Street to go to this little restaurant for lunch. I'm sitting in the passenger seat, and there's a lot of people out. It was a nice day like this. I said, gee, Tom, look at all those people out there. They're all looking at you. They all know who you are. They're probably wondering, who's that guy that the Chief Justice is driving around Columbus? Tom never batted an eye. He just parked the car. We had lunch. And then it was Thursday of that week, and he says, let's go to lunch. I said, fine. We're down the parking garage. The two of us meet in the elevator. We're walking out. He looks at me and he says, why don't you drive? The character of Tom Moyer.
Yeah.
Everything about instilling public confidence in the decisions of the Ohio Supreme Court. Tom was a great individual, and that's a fond memory that I have of being on the court.
I echo that. Tom was, you don't meet many people like him. He was the nation's second longest serving Chief Justice, and he was a man of just incredible integrity. I mean, I miss him dearly. And unfortunately, I didn't get the chance to serve with him, but I had two favorite memories of being on the court. One is that we were a female majority, and I would poke at Terry and be like, we're going to the ladies' room. We'll be right back with our decision. And my second favorite memory is people like, I was the only Democrat on a 7-member court. And I remember I was a little hesitant about, joining the court. And the then incoming Chief Justice Maureen kept saying, you will be welcomed here. Your colleagues want you. You don't have to worry about anything. And that is the way it was. I mean, from the time I joined the court, it was one of the best experiences of my life. I got to serve with Terry and 5 other people that were simply amazing. And we would have some spirited debates. And anybody who knows me knows I don't back down from a position. And Terry liked to, I don't know how many of you remember the Staples commercial. There used to have this Staples commercial with a red button and you'd hit it and it said, that was easy. And so Terry had one of those. And we were having a particularly animated conference where I felt pretty strongly about my position. And when we were all done and everybody had done their votes, Terry hit that and said, that was easy. And so it completely, it made the mood light. We could walk out of conference and go to dinner. And it was just a special court. We didn't always see the law the same, but we didn't take it personal. And we were able to go out and socialize. Terry had us up to Catawba once, and we went on boats together. It was just a really wonderful place. I bet you guys do that now.
We were a very, very collegial court. In fact, Yvette's talking about the 4-women majority. I don't think I've ever told this story, but we have a conference room. So after we would hear oral argument, we would have some vigorous discussion with whoever the oralist was, and then we would usually go to lunch and then come into the conference room. And in our deliberations, there's no recording. No one is allowed to record anything that's said. And there is an air of secrecy about what goes on. It's only the members of the court. Don't I get into the conference room early, and I had been to Walmart or someplace and found a little tag that you would put on a bicycle, and I hung it up on the wall. It said, "Girls Rule."
He did.
Come into the conference room, and everybody's like, where did that come from? I have no idea. And I think to this day, nobody knows
right,
that I
we
did
did
that.
not
This is
know.
an admission against interest. too late, I'm off the court. But we did have a very collegial group, and a lot of that was promoted by the fact, again going back to Tom, we would meet in Columbus, and Tom always had a court dinner. So he would select a restaurant, and then we would go out to dinner as a court on a regular basis. And you would just talk about, not cases, but you would talk about your lives and how things were, and we got to know each other really well. And building that collegiality really translated into the conduct we had in the courtroom during oral argument, and also the way that we would conduct ourselves in conference when we would discuss some really difficult cases.
Former Justice McGee Brown, can you tell the audience, the non-lawyers, a little bit about where we fit in, the Supreme Court fits in the state of Ohio's judicial system?
So I heard in the introduction we were called the court of last resort, but the reality is we're not really. Mostly the 12 courts of appeals are the courts of last resort. The Supreme Court only takes cases that have a constitutional impact or of great general interest. And so the reality is for most litigants, their cases end at the Court of Appeals. Our Supreme Court now takes 4 to 5% of discretionary cases. There's some cases they have to take as of right, of course, death penalty cases, utility cases, some workers' comp cases, but for the most part, it's discretionary. And so litigants need to understand that your chances of getting in, I was telling Terry at lunch when I tell my colleagues, Lewis, I think you may be the one that said this, but we routinely try to get into the Ohio Supreme Court, and even though I used to be there, I've not figured out the magic of getting accepted. And Lewis said to me one day, can't you put a sticky note on there and say, hey guys, it's me? So there's no preference given to having been a former justice. You need 4 votes to get accepted, and if you don't get those 4 votes, you just don't get in.
That's right. But I'm going to ask your colleague here, former Justice O'Donnell, to tell those law students, how does a party get a case in to be heard oral argument?
So this is an interesting aspect of the jurisdiction of the Ohio Supreme Court. Yvette referenced the fact that we take all the death penalty cases, we take all matters from appeals of the Public Utilities Commission, we take some appeals from the Board of Tax Appeals, and then any matter of public or great general interest. And then, of course, we take matters that have been certified from a federal court on a question of Ohio law, and then we would take any constitutional issues that would be of some widespread interest. So when you think about the Supreme Court as the highest court or the court of last resort, go back to the trial court. There you have witnesses, there you have a jury, you have the presentation of evidence, and it's a very busy place, and it's all recorded. And then we have the Intermediate Court of Appeals. I could call it the loser's court, because if you lose in the trial court, you automatically get to go to the Court of Appeals. And 3 judges there will listen to any argument that is presented by the losing party in the trial court. Their role at the Intermediate Court of Appeals is to determine, by looking back at the trial court, whether there was any mistake made. Did the court issue the right jury charge? Was evidence admitted that should not have been admitted? Was there some error in the proceeding? And those mistakes are called assignments of error. And the Court of Appeals will rule on any of those assignments of error and issue its decision. And then you come to the Supreme Court. If you lose at the Court of Appeals, you don't automatically get to go to the Ohio Supreme Court. You must file what we call a memorandum in support of jurisdiction, asking the court, will you hear this case? And of course, your opponent is on the other side saying, there is absolutely no reason you should hear this case. This is a memorandum opposing jurisdiction. And so we, while we were on the court, would regularly review as many as 100 requests, or jurisdictionals, as we called them, to see whether or not the case would or would not be admitted and heard by the Ohio Supreme Court. And as Justice Fischer pointed out, we would only take very few percentage, 4 or 5% out of 100 would be admitted for and scheduled for oral argument. Now, the role of the Supreme Court is not to look back at the Court of Appeals to see if that job was done correctly. It was not to look back at the trial court to correct a mistake that was made. The function of the Supreme Court is to look out at the entire legal community and see whether or not there is some issue that is confused in the legal profession or not well understood, or a constitutional issue that needs to be resolved. So the court is looking out to try to make some rule of law that will apply to all similarly situated cases. Its role is not to correct mistakes made by another court. That's the Court of Appeals, the mistake correctors. Supreme Court are the rule makers, and that's why we say we are the court of last resort. We are final on all decisions made except for federal constitutional issues. So you could take an appeal to the U.S. Supreme Court on a constitutional issue from the decision of the Supreme Court. Other than that, the Supreme Court is the court of last resort.
Which is why Terry would always say at oral argument, what's the rule of law you want me to write? Because it doesn't matter if a lot of lawyers make the mistake of getting up there and arguing about how wrong the Court of Appeals was, and Terry would let them go on, and then he'd be like, what's the rule of law you want us to write? And I was amazed at how often people would stammer. They wouldn't have even thought about that. And so even now, when you go before the Supreme Court, you need to know what you want them to do. It's not just you want them to reverse or affirm. What's the rule of law you want them to write? Because that's what the Supreme Court does. It writes rules of law.
That's correct. And I want to point out that I've been on the court 7.5 years. One case has been accepted by the U.S. Supreme Court. So to say we're the court of last resort is kind of, and it was on a federal constitutional issue. Otherwise, the cases just don't go up. Justice McGee Brown, after oral argument, as Justice O'Donnell noted, we go back and have deliberations. What's the difference between how we assign who authors the opinion versus the U.S. Supreme Court?
So I think Justice Roberts makes the decision, or
senior justice
in the majority.
Yeah.
So with ours, after we vote, and we go around, we have this huge vote table, and
Octagon.
Octagon. I was always the junior justice, so I always voted last, and I could count. So I'd be like, 1, 2, 3. I can make this go either way I want. So whoever is in the majority, the justice in the majority, we have this leather flask. Is it still there, the leather flask? And Justice Pfeiffer was the keeper of the leather flask. I think he hated me because I...
And then when I was there, it was Justice O'Donnell, and now it's me.
Oh, you get to... So each of us has a marble with our number on it, 1 through 7. If you're in the majority, that marble goes in the flask. It's a very scientific process. Your number goes in the flask is shaken, and then 1 marble comes out. I think Pfeiffer found a way to code which marble would come out. But anyway... The marble comes out, and you're the person assigned to write the opinion. We had an opinion once that the trial lawyers, who were very supportive of me during my campaign, cared a lot about this case. And it was unanimous. That didn't go their way, 7-0. But the person that had to write it was me. I'm like, are you freaking kidding me? There's 7 people. I got to write this opinion. I heard about that for years. So that's why I think Pfeiffer had some way of messing with that marble.
I don't know how he did, but I haven't figured it out. Justice O'Donnell. In the newspaper, it's always 4-3. Okay? There's 7 of us. But could you tell the people in the audience, I mean, 60-some% of the cases are unanimous. If you include 6-to-1 votes, it's almost 75%. Why do people have this perception of this division that really doesn't exist?
People identify with certain members of the court. As we're elected officials, people identify with a philosophy that a justice might have, and they're trying to anticipate what outcomes might be. And people identify with outcomes. What's really not understood is we take an oath to support the Constitution and the laws of the state of Ohio. And in our adherence to that oath, it doesn't say anything about helping those who helped you or making decisions that will be favorable to a certain segment of the population. And so just like Justice McGee said, yeah, people helped me, but I had to write an opinion that they might not agree with. And so I think that there is a perception in the public about political divisions, which really is not the process. When we finish oral argument and get into our conference, you can imagine 7 people bursting at the seams to sort of say what they think should happen in this case. But the procedure is really quite orderly. Every member of the court wants to have his or her opportunity to express a viewpoint. And so the procedure that we've followed for decades in our deliberation room
and still do
is that the Chief Justice will speak first. And the Chief Justice will announce the case and maybe cite some statutes or give some viewpoints about how he or she thinks that case ought to be decided. And then by seniority, with the most senior justice going next, each member of the court has an opportunity to address the conference. You can take as long as you want, or you can pass. It's just a matter of your own influence that you want to have on that particular case outcome. And by seniority, we work our way down to the very junior member of the court, so that all 7 members of the court have an opportunity to express their viewpoint as to how the case should be decided. And after those 7 presentations have been made, then it's open to cross-table discussion. And sometimes it gets very heated. And other times it's more orderly or all in agreement as to what the outcome should be. And once the cross-table discussion has been completed, then we vote. But curiously, we vote in reverse seniority order, so that the junior member of the court is the first vote cast, and we vote up in reverse seniority, and if there would be some 3-3 division, it is the Chief Justice that will cast the deciding vote. And those would be the marbles that would go into that little leather bottle, and someone would be assigned to write an opinion. And then that opinion comes back to the court for further discussion after it's drafted. Maybe a month, maybe 2, maybe 3 months later. And anyone on the court could write a dissenting opinion if they didn't agree with it. Anyone on the court could ask for changes to be made during our discussion of that opinion. And so sometimes people are like, well, gee whiz, you argued that case on March 10th. Here it is July, and we don't have a decision. Well, that process can take 6 or 7 or 8 or 9 months before that decision and the opinion is done, and all members of the court have had a chance to vote on the final drafts, whether they're concurring or dissenting opinions, or the majority opinion. And then that matter gets released to the public.
And sometimes you can flip a case. So, and I know Justice Fischer's talked about that. I did that a couple of times. If you feel strongly about a case, and it's funny, you'd get into conference and you'd be, I think I knew how people were going to vote, and they'd vote different. And then if you're in the dissent, you go back and you write a strong dissent based on the law, you can pick up a couple of votes, and then you can flip the case so that you're now in the majority, so then you have to then author the majority opinion, which takes even more time. But the reality is, for most of the cases, it's a unanimous decision, or 6-1. So there's not acrimony in the way that people think. It is very collegial. One of my best memories is Justice Cupp, who was the second junior justice to me. We had my first conference, because I guess I didn't hold my tongue. I was just like jumped right in. And the conference went really late till after 6. And I'll never forget that Justice Cupp came down to my chambers and he said, I don't agree with you, but walk me through it again. He sat down on my sofa. It's after 6 o'clock. We'd been there since our 9 o'clock docket. And he sat there and I walked him through my argument again. And it was my first conference. And he had no reason to do that other than he wanted to hear my point of view. Now, I ultimately didn't win him to my side, but I gained a lot of respect for him that he was willing to listen and to hear me out.
I have to admit, this flipping, I once had a case. My number 5 rolled out, so it was 4-3, and I wrote it. Somebody wrote a dissent, and it flipped the court. And I wrote, and then they changed it to a majority opinion. I wrote a dissent using it flipped back. Wait, it went flip back the other way and flip back to me. I wrote the majority opinion it was released 16 months.
Oh, wow.
After.
Well, yeah.
And it was a very close call, and it's been in front of us again a couple times.
That wouldn't have happened under Moyer.
All right, well, let's move on. The Ohio Supreme Court has an administrative docket, including appointments, people don't realize, to 40 different boards and committees. Okay? I don't know whose turn it is. Talk about how we oversee the lawyer discipline system.
Oh, I'll give that to you.
Now, you'll find this to be amazing, but not all these lawyers are perfect. So what we do is administer a bar examination, and then we have a board of character and fitness. And we do try to screen to get the best people to be involved and admitted to the bar. We have an admission ceremony, and the Supreme Court is charged with the admission and the discipline of every lawyer in the state of Ohio. We have about 40,000 lawyers throughout our state.
But wait a minute. But you guys are getting soft. It's like 2 days now for a bar exam. I want to register a complaint.
I have to say that's undecided as of this point for you law clerks out there. Hasn't been decided yet.
2 days, ridiculous. Go ahead.
In any event, we also have disciplinary counsel. And anyone who has been aggrieved by an attorney can file a complaint with disciplinary counsel, and an investigation will ensue to determine whether anything has been done improperly. Many times we have referrals from probate courts because the estate accountings are not done on a timely basis, and some of them don't square and balance properly, and we find lawyers charged with criminal theft out of estates. And these are matters that are investigated by disciplinary counsel, and lawyers then are subject to sanction. We have panels who hear, as a trial, all the facts of a particular disciplinary case, and those matters also come as part of the docket of the Ohio Supreme Court. So we can suspend an attorney, we could issue a public reprimand, or we could disbar that lawyer, depending on the gravity of the offense. And it's part of a regular docket that our court maintains and permanently record whatever that sanction is against that individual lawyer.
If you're interested in the process of courts, as Justice Fischer said, the court oversees 40 boards and commissions. You can write to a justice. Each justice gets to appoint somebody to one of those commissions, and it goes in order. So every time when it's time to do appointments, I don't remember if it's January, February, we get this leather book, and you're told which appointment you have on the various boards and commissions. So if you are interested, because you're interested in court, you're interested in attorney discipline, you're interested in the art that's in the Supreme Court building. There's so many different commissions. You can write to a justice and ask to be considered when he or she is making their appointments to the boards and commissions.
And we'd rather have people that are interested than us calling people. Would you be interested in doing
That's
that?
right.
Let me ask this question. When you two ran for justice, there was no party designation.
Right.
How do you feel about the fact the General Assembly now says that you're going to be a Democrat or Republican when you run?
I don't like it. I mean, and even though, look, it's the name game. You know, not most people don't know who their justices are that they're voting for. But the reason I don't like the party affiliation is what Terry said earlier. It makes people think you're getting a particular point of view. When you vote for this person, like your elected representative, they're going to vote the way that you think all Republicans or all Democrats vote. And that's just not how it is. These are 7 people who I think come to the job with intellectual honesty. We may disagree on whether you're a textualist or an originalist or you think the Constitution is a living, breathing document, whatever your point of view, we never once discussed politics in the conference. And what I think it does is it undermines the public's confidence that this is really a court who is calling balls and strikes based on the law as they understand it. And I just don't like having a party designation that makes people think that their person is now on the court.
Terry?
I concur. I don't think that the party designation helps because it sort of leads to this 4-3 decision outcome that you talked about earlier, because we should win if we have more of these or more of those. And it really doesn't have anything to do with the actual disposition of a case, because, as I indicated earlier, our oath is to support the Constitution and the law. And we don't discuss politics as to outcomes on cases. And I've been down there longer than you have. I've been there a while. But we don't discuss politics as a matter of case outcome. We try to do it based on the law. And one of the reasons we do that is because we do try to instill public confidence in decisions of our courts. And we've had case outcomes that have gone just totally awry. Before I got on the court, there was a case out of Canton, Ohio called Scott Ponzer.
Oh, yeah.
This was an insurance case. So some of you are laughing about it, but strangely, it was an uninsured motorist case. And the gentleman was killed in a car accident while he was in his wife's car. And his uninsured motorist coverage provided a payment to his widow, Christine Scott Ponzer. And then he worked for Superior Dairy. And even though he wasn't on the company time, and even though he wasn't on company business, and even though he wasn't in a company car, the Supreme Court of Ohio ordered a $100,000 payment out of the company's insurance coverage to be paid on that claim. And people were scratching their heads. And Tom even said to me, he said, I'm at conferences around the country, and they're saying, is that really the law in your state? There were 44 cases that were decided along that theory. It got so bad that I believe 3 members of the court wrote in an opinion that a helicopter was a motor vehicle for purposes of uninsured motorist protection in the state of Ohio. And it just didn't do anything to help our jurisprudence. And so eventually that case got overturned, and we sort of got back to a more acceptable and understandable body of law with respect to uninsured motorists. But those kinds of decisions, whether politically motivated or oriented to help one group or hurt another group, don't do anything to instill public confidence in the decisions of the court. And so when you have justices who will adhere to the rule of law, who will apply the statute or the law to the facts of the case, you do instill public confidence. And I am privileged to have been able to serve at a time when we did have great public confidence in our court.
And it's important for our economy, too, because businesses want certainty. They want to know what the rules are. And if you have a court that's flip-flopping and making political decisions, you're not going to have companies want to locate here or grow their businesses here. At the end of the day, regardless of what the decision is, they just want to know what the answer is. They want to know what are the rules, and they want there to be predictability in how the rules are applied. That's what judges do. If you want to be a politician, you should run for the executive or legislative branch. That's not who judges are. That's not who they should be anyway.
No. And I want to say that one of my proudest weeks was the plain dealer called me the swing vote.
I saw that, yeah.
And I got yelled at by the head of the Republican Party and by a leading Democrat the same week for the same case. Anyway, we're at 12:35, so this is your chance. There's a lot of questions that you asked I probably ethically cannot answer, but these two can certainly answer. So
We'll answer them ethically, though.
All right, we are about to begin the audience Q&A for our live stream audience or those just joining. I'm Cynthia Connolly, Director of Programming here at the City Club. Today we are getting a peek behind the curtains of Ohio Supreme Court. Joining us is Justice Yvette McGee Brown, partner at Jones Day and former Justice of the Supreme Court of Ohio, and Justice Terrence O'Donnell, former Justice of the Supreme Court of Ohio. Moderating the conversation is Justice Patrick Fischer of the Supreme Court of Ohio. We welcome questions from everyone, City Club members, guests, and those joining via our live stream at cityclub.org. If you'd like to text a question for our justices, please text it to 330-541-5794. Again, that's 330-541-5794, and the City Club staff will try to work it into the program. We have our first question.
Hi, my question has to do with qualifications for being an Ohio Supreme Court Justice. There was a time in U.S. history where a president could nominate a justice to the U.S. Supreme Court, and that person didn't necessarily have to have judicial experience, thinking, for example, of Earl Warren and Abe Fortas, and there are others. Not being Steve Steinglass, I'm not as familiar with the history of the Ohio Supreme Court. So my question is, all of you had prior judicial experience before being elevated to the Ohio Supreme Court. How important do you think that prior judicial experience is or was for you, and do you think that's something that every potential justice for the Ohio Supreme Court should have? Thank you.
I think it's important. I think you need to, I was a trial court judge, and I think you need to understand what goes on in a trial court. It's pretty fast moving. You're doing 20, 25 cases a day, and I remember one of the senior justices told me once, like, the court speaks through its journal entry. So if you say something improvident in live court, just make sure your entry follows the law. So you have to know how courts operate and the pressures that judges are under, how they handle jury trials. I mean, I think it helps understanding how courts operate. But could somebody come in who's just an intellectual and do it? Maybe, because they've got 6 other people that can correct them if they're wrong. But I do think it helps.
I think you're absolutely correct. I think the more experience you have in the judicial branch of government, the better you are able to determine, number one, which cases should be brought in for review and how they should be decided. In the last analysis, we're trying to explain what is confused in the legal profession so that lawyers and litigants can understand it, and so that the judges who have to apply it understand what they should be doing. And that is a unique role of the Supreme Court. And the better you are experienced, the more the litigants will accept it, the more the lawyers understand it, and the more the judges are inclined to follow it. I mean, if you have someone who's no experience and decides, oh, we're going to do this now, judges are like, well, I'm not doing that in my courtroom. You can say it's a good idea, but and so you can gain acceptance because you understand what your colleagues in the judicial branch are doing, and you can be a better jurist.
Keith?
So many questions, but I'll just
One.
Just the one. In my years of practice, I noticed that the Supreme Court spends a disproportionate amount of time doing arcane workers' compensation mandamus cases. And my question is whether you would recommend changes in the jurisdictional mix that the Supreme Court takes so that you could spend more time on important public questions that come through the courts of last resort, and less time on workers' compensation mandamus cases that really don't apply to most people.
I honestly don't. I don't think that there's any group of cases that are keeping the court from accepting more cases. I just think the court needs to accept more cases. And I've said, I mean, as a practitioner now, it's really hard to know what's going to get in. You're writing to 7 people who are, we get, this hasn't come out yet, we would get 5 bankers' boxes of files in a 2-week cycle. And so you're reading through jurisdictional memos, 100 or more, plus you're reading mandamus petitions and certified questions and utility cases. And so you're making decisions individually on cases you think should be accepted or declined. What I would love to see is to see the court accept more civil cases that would help the business community figure out what the rules of the game are. The workers' comp cases, I've been away from it so long, but I don't know if
we have to take on several of them as a problem.
Yeah. Well, the legislature would have to change it.
Right.
Yeah. Well, you talk to them.
So the Supreme Court does have a legislative liaison.
Yes.
And so there is a mechanism where the court can speak to the legislature. And if there are these sorts of issues that Keith pointed out, we can ask the legislature to consider an alternative means for disposition on some of those cases. But as the legislature writes the law, even though we're on the Supreme Court, we still have to follow it. We're not allowed to sort of make it up as we go along and say, well, we're not going to pay attention to that. So, like everyone else, we also have to adhere to the law as it's written. But if it were changed, then we wouldn't be obligated to do that.
Yes, ma'am.
A function of this is, let me just finish up, Pat. A function of this is the number of cases that are being appealed to the Supreme Court. So at a time when Yvette and I were serving on the court, we did have literally hundreds of jurisdictionals to consider because all the courts of appeals decisions were being appealed to the Supreme Court. Over time, and as we approach it now, number one, COVID has had a tremendous effect on the legal profession. We've changed the mechanism for trial. We've gone to Zoom trials, and we have arbitrated and used dispute resolution to resolve cases. Plus, the cost of litigation has increased. I mean, it's not unusual to tell you that lawyers in New York City, for example, are $1,250 an hour. We have lawyers in Ohio that are $750 an hour.
Or more.
It's very, or more, excuse me, $950 an hour. What do you charge? She's with that big firm, Jones Day. Dick, you better check on this. So what am I telling you? It's very costly to present a case to the Ohio Supreme Court. And that has a direct effect on whether or not the case will ever get appealed to the Ohio Supreme Court. And so over time, because of factors that are beyond the control of the legislature or beyond the control of the judicial branch of government, we don't have as many cases today. It may change next year, it may change in future years. But once again, these are waves that come and go, and the court has to stay very constant with respect to its discharge of its duties on the cases that it accepts.
Yes, ma'am.
We use and we hear the words constitutional crisis as non-lawyers, but I wondered if you could tell us from your perspective what would or does constitute, a constitutional crisis on a national level, and also if you could answer on a state level what your rules are as far as accepting gifts or, vacations or anything.
Well, I'll take the first one. You can take the gifts one. And this is just my personal view. I think, a democracy thrives on having three functioning branches of government. And a constitutional crisis to me is if people lose confidence in the courts. If people lose confidence in the courts, you have three branches of government for a reason. And if you look at how the framers set it up, they understood the politicalization of the executive and the legislative branch, and they set up the court system to be the arbiter or independent tribunal of deciding disputes that come up from the executive or the legislative branch. And if people start to feel as if their courts are political, I think you start to undermine the confidence in the rule of law. And no matter the problems we have as a country, we are a country based on the rule of law. And I don't ever want to see that go away. And I think it's incumbent upon all of us, whether you're a lawyer or not, to support the rule of law. And when people start to trash the courts or talk about how the courts are political, we need to stand up for that, because for the most part, they're not. People look at hot button issues, and as Justice Fischer said, you look at the United States Supreme Court, yes, they have 4-3 or 5-4 decisions, but a lot of their decisions, the majority of their decisions, are unanimous or 6-1. And so we've got to keep things in context. And I wish people would read more and stop listening to just what they hear the pundits say on TV.
Terrence, you want to say?
Well, with respect to gifts, there's a certain ethics that judges are bound. And so we follow a code of professional ethics. And it's with respect to political campaigning, and it's with respect to acceptance of gifts. And generally, judges don't accept gifts in Ohio, period. And if you do, you're subject to some sort of disciplinary action or grievance filed and subject to the discipline of the disciplinary board and ultimately the Supreme Court. And we have disciplined judges regularly in Ohio.
True.
Thank you for that question.
Judge?
Some time ago, the Supreme Court had entertained the possibility of establishing a criminal sentencing database, taking into consideration that the courts have wide discretion as it relates to how they decide what kind of sentences are meted out to different individuals. And the purpose of the database was to try to kind of have a conglomerate of those opinions in order to make some determination as to whether or not those decisions were made in a fair way. And it was being considered by the Sentencing Commission, it was being considered by the Supreme Court, but there hasn't been much said about it now. I just would like to know from the former judges, because I know Judge Fischer's not in a position to speak on it, but what your thoughts are about the possibility of creating a criminal sentencing database, and what the positives and the negatives would be for doing so.
I think it would be great. There was huge outcry among trial court judges that any data collected would be used against them when they ran for re-election. That's always the argument when you try to collect data on what trial court judges are doing, is that they fear that their opponent will take that data and use it against them. My philosophy is you do the work. You do the work and you let your decisions, you stand up for them and let the data be what it is. And if anybody is challenging you, you should have enough confidence in your decisions. And overall, they should be fair enough that you should be able to articulate why your stats look a particular way. But when you elect judges, their biggest fear is their next race and their next opponent.
So sentencing is a really difficult problem for all judges throughout the state. The legislature has changed sentencing regulations at least 10 times in the last 20 years. And what have we done? We've gone from indeterminate sentencing, 5 to 25 years, down to determinate sentencing. We've imposed gun penalties. If the gun is used in an offense, a judge has no discretion, must impose a 3-year period of incarceration. No questions asked. consecutive with whatever the other sentence is. And so these kinds of problems percolate through the system all the time. And the legislature is charged with establishing what the sentencing is, and the judge is charged with exercising the discretion within the bounds of what the legislature says the penalty is. So at the moment, for example, we have indeterminate sentencing, 6 months, 12 months, 18 months, or 24 months. So a judge could pick any one of those that he or she desired and put that in as a sentence on a particular felony offense. But the judge has that much discretion. And so this comes from what the legislature says the penalties are. The Sentencing Commission that Justice Adrien is talking about was designed to try to streamline what it would be, and it was a response, but I can't tell you where that is. The other issue that we addressed recently was bail reform. And this was something that we had too many people in jail waiting to go to trial. So we're going to reform bail. And so they did reform bail. And now if you get arrested, you can almost walk out the door after you're processed. And so now we're experiencing people who have been released and committing additional crimes. And so this is another ebb and flow that we're watching in society based on perceptions that things aren't what they ought to be. And so there likely could be further changes, either on sentencing and or on bail reform or other issues affecting the criminal justice system.
The legislature keeps trying to take away judicial discretion, which I think is a mistake. I think you elect judges to make decisions. And I can remember being a trial judge going to the legislature when they were putting in these mandatory minimums. And I said, well, if you don't want judges making decisions, then just put something on the police wall. And when somebody walks in, say, this is your charge, this is your sentence. You want judges who look at the defendant, somebody from your family individually, to look at, does that person have a prior record? Have they been involved in crimes before? Do they have a supportive family? Do they indicate they will abide by the court's rules? Putting these mandatory sentences in where you take all discretion away from judges is simply not justice. And it removes the ability to look at every person. If your family member is before a judge, you want that judge looking at that person, not looking at a rule book that says, I'm sorry, this is your first offense, but you committed this offense, never been in trouble before, never done anything wrong, had a momentary lapse, but you're going to prison for 10 years. That is not a system that you want. And the only way that changes, ladies and gentlemen, is if we are engaged in who we elect to office. You've got to be able to say, we want judges to have the discretion to make decisions. And if that judge is making a bad decision, then vote them out of office. There's a process.
Yes, ma'am.
Good afternoon. We have a text question. The Supreme Court sets the number of courts at the local level. Some say that part of the challenge with criminal justice reform here in Cuyahoga County is that there are too many judges. What would it take for the Supreme Court to reduce the number of judges in a place like Cuyahoga County?
Well, the premise there is incorrect.
Right.
The General Assembly.
It is not the Supreme Court that sets the number of judges. It's the General Assembly. So that is a matter that could be easily addressed to a state rep in Cuyahoga County or in another county as to why there are so many judges in one county and so few in another county. And
Cuyahoga County does have a lot of judges. Well, because you have what, 64 municipalities that sit in Cuyahoga County, and each of those municipalities has their own municipal court, their own police department, their own fire department. You guys need a regional solution because you got way...
Thank you. No, I mean, the premise just isn't right. Yes. Thank you.
Thank you so much to our justices for joining us today at the City Club. A round of applause for each one of them. Forums like this one are made possible thanks to generous support from individuals like you. You can learn more about how to become a guardian of free speech at cityclub.org. Our gratitude to Stephen Stover, Mr. Dick Pogue, and the Chief Justice Moyer Legacy Committee for their partnership on today's forum. as we honor the most important tenets for which he stood: legal and civic education, ethics, civility, others, but especially the rule of law. Please join me in welcoming guests at the tables hosted by the Chief Justice Moyer Legacy Committee and Jones Day. Thank you all for joining us. And next week at the City Club on Tuesday, June 25th, we will hear from key leadership in Cleveland's Arab American community who hold Palestinian heritage on how their community is faring and what is needed to move forward toward equity and peace. And then on Friday, June 28th, we will welcome Maisha Watkins as part of our Local Heroes series, and she will talk about her work on community violence intervention right here in Cleveland, particularly the East Side. You can get your tickets and learn more about each of these forums and others at cityclub.org. And that brings us to the end of today's forum. Thank you once again to our justices, and thank you members and friends of the City Club. I'm Cynthia Connolly, and this forum is now adjourned.
For information on upcoming speakers or for podcasts of the City Club, go to cityclub.org.
Production and distribution of City Club forums on IdeaStream Public Media are made possible by PNC and the United Black Fund of Greater Cleveland, Incorporated.